Nicole. Okay, firstly, I have been meaning to do this for a very long time. I need you guys to say cheese. And once more, cheese again? Yeah. Oh, you guys are so beautiful. Thank you very much for that. All right, so if I can work the technology. Okay, so we're going to talk about challenging the survey. On the brochure that you guys have for the agenda for today, it says we're going to talk about challenging a survey, doing a change of ownership, and also FGI things. And if you raise your hand if you have no idea what FGI is. Okay, just a few people. That's a Facilities Guideline Institute that provides some of the facility standards, the physical standards associated with residential assisted living facilities and healthcare facilities in general. We may have time to talk about that. I will say that those are the three things I'm supposed to talk about. Per your agenda. Per the agenda I received, I'm talking about this. So if we have some time left over, we'll talk about those additional things. And I happen to have our resident FGI expert here, Michelle Pinkowski, my lifelong partner of 30 years and law partner in the business. And an awesome person who's a resource on this. If you haven't talked to her yet, make sure you do before you go. Okay, challenging a survey. So the theme of this convention is what? Anybody remember? Courageous, right. So now we heard meddlesome. Meddlesome is an awesome way to describe courageous. And that is one of the things that the Assisted Living Association does for Colorado. There's another word. Courage requires the ability to confront people and things. And by confront, I mean to face without flinching. Just to be able to examine a situation, a person, or whatever without flinching. Now, you all are awesome at doing that with respect to families who might be agitated about one thing or another, or residents who might be agitated about one thing or another. And sometimes, because you're good-hearted people, not so excited about confronting state surveyors and other kinds of people about things, because they can be kind of scary and a little intimidating. And although we heard from Steve Cox this morning kind of a picture of reasonableness and rationality, laughter, I love that. Raise your hand if the picture he was portraying was slightly different than that experienced by you and your surveyors. Okay, so maybe there's a little gap there in terms of what's going on in the world. So we're going to talk about what you need to know so that you can face without flinching what's going on with the government. I was going to introduce myself, but that has been done really, really well. Thank you very much, Nicole. Okay, so I'm an attorney, so I'm going to make a disclaimer. This is not legal advice for you and your situation. This is general legal information, education, if you will, about what's going on. If you do have a situation that you want to talk to us about, and it often sounds like this, yeah, but I have this situation where this is happening. Can I do this? Can I do that? That's specific legal advice, and you should come and talk to us separately or talk to your own attorneys. Which leads us to the basic concepts. No, that's not right. Intermediate condition. Everybody know what an intermediate condition is? Not a lot of raised hands. Okay, so an intermediate condition. Is this restrictions or conditions on a license that is out of compliance? It is a deficiency, usually of the D and E level that we'll talk about. So that's a funny word, right? Intermediate condition. So you'll get a letter from the state if you've been fortunate or unfortunate enough to get one. It says an intermediate condition notification or words to that effect. And that's a funny word. What it means is intermediate condition or restriction on your license. Because it affects your license, you have a lot of legal rights. There are 5 levels of intermediate conditions. You guys know these? Raise your hands. You don't know the 5 levels of, sorry, not intermediate. There's 5 levels of deficiencies. You know these? Kind of? Everybody sort of does, mostly does. If you don't, God bless you, you've been fortunate. That's been awesome. So these are the ways they grade the deficiencies that they find if they take a look at your facility and say something is not proper. And these come from CMS at the federal level. The state didn't come up with these on their own. These are common around the United States. They come from CMS. The ones you're most likely to call Michelle and I about are the E and D level deficiencies. However, there's a word here. There's a couple words here we need to go over. One of these words is pattern. Okay. This is in the regulations. Will you show me a pattern of fingers? What in the world am I talking about? Right? All right. He's got 3. Show me a pattern. Anybody got a pattern? All right, he's got 5. 5. 5. All right, is this a pattern?
No.
Is this a pattern?
Yes.
2 is a pattern? I have a pattern of fingers? Okay. Guess what is not defined in the regulations? What a pattern is. So this is something that we have an opportunity to push back on with the state. Because if something has happened before, they're very quick to turn around and say, oh, well, you have a pattern of deficient behavior, or a pattern of noncompliance. I think they like to put it that way. So that's a thing. Another thing is, of course, this concept of immediate jeopardy. And the way it's written is actual potential for serious harm, injury or harm for one or more residents. There's a lot about immediate jeopardy that should be questioned. Should be questioned a lot. I have seen an immediate jeopardy cited against somebody who had a chair partially in a doorway, a little hallway kind of a chair, partially in a doorway while people were cleaning. Just cleaning, we're going to put the chair partially there and then we're going to move it out of the way. Okay? All right, is that an immediate jeopardy? My goodness. We would have a difference of opinion on this if I was a state surveyor because, in fact, they were cited for this. They were cited for this. That's just kind of wrong, right? Wait a minute. Why is that wrong? Opinions? Anybody? Why is it wrong? Janet?
Is the chair in the hallway or in the doorway was a potential hazard for harm? Should the resident need to be evacuating that room for fire?
Okay. So, did you guys get that? So, if a resident needed to be evacuated in the case of a fire. But we were cleaning, for God's sake.
And there wasn't a fire.
And there wasn't a fire.
I don't know, it says potential. There's a potential fire. It doesn't say there is a fire.
Potential, exactly. There's a lot to talk about with respect to intermediate jeopardy, and I did what I think is a pretty good overview for CALA that you can find on the website, and I believe you've either been introduced to that or otherwise there's a video overview of this. But the short version of this is that these things come from CMS, federal. They recognized in 2019 that intermediate jeopardy needs some clarification. We need to talk about likelihood, right? Is it really likely to cause something to go wrong? I know a guy who had a 4-to-1 caregiver ratio, and they cited him for immediate jeopardy because the window that somebody was near could have been opened, and they could have possibly fallen out and had a 4-foot drop. Really? Really? Is that really a problem? Depends on the surveyor. Yes.
Couldn't everything be written up as immediate jeopardy then? Because I can have a resident using scissors, and potentially that resident could cut themselves. Potentially they could walk with the scissors. Like, I feel like if that's the way we're interpreting it, everything can be written up as immediate jeopardy.
Did you guys hear that? And that's the problem, isn't it?
Yes.
So, I thought Steve made a very good presentation this morning. I thought his heart was in the right place talking about things. But there is a vast gap between what he was describing and what Elaine McManus described on the video thing a couple weeks ago, and what you see from surveyors. And that's what we're trying to do as an association and as attorneys, is try and help close that gap so it's not so much drastic discretion on the part of surveyors who frankly aren't in the business. Right? Okay, moving forward. So, okay, sometimes we ask the health department to do, how come they're not doing more education? How come they're not helping more? How come they're not trying to make corrections of things? Why aren't they doing something to be better partners in the industry? And the answer to that is found in the Colorado Revised Statutes, Chapter 25, Section 1.5.103, where they're welcome. You're welcome. Where this is it. This is the scope of it with respect to health facilities. License annually and establish and enforce standards. Enforce standards. This kind of instruction from the legislature creates a different mindset than we're here to help. You can't help it. That's what they've been told to do. It's not bad. This is a result of do-gooder legislators who think that things can be enforced. We'll talk a little bit more about that shortly. And just FYI, it looks like we will have time, Michelle, to talk about additional things. So when we talk about the citations that flow from this, we want things that can be fixed, right? We don't want them just going out and slapping people. Hey man, that chair was in the way during the few seconds while somebody was mopping just right next to the doorway. Well, they're not supposed to cite for any deficiency from an isolated event that can be effectively remedied during the survey or inspection of the health facility. They're not supposed to. So this is what you and I were talking about just a moment ago, Jen.
Sorry. It was so exciting.
Thank you very much. I don't usually get this response from my wife, but it's glad to know the thrill is still there. Thank you. So, but there's more to that. So this part makes perfect sense, right? Well, yeah, fix it if it's right there. Doors open, close it. If there's a can open, close it. If something's there, get rid of it. Fix the problem. Let's not make a big drama out of it. However, they followed it up with this. Unless the deficiency caused harm or caused a potential for harm? Are you kidding me? Caused a potential for harm? Created a life or limb-threatening emergency or was due to abuse or neglect. Now, most of that's understandable, but it caused a potential for harm. A potential. As some of us who've read surveys know, that can often be written up as, could it possibly be imagined that a harm could take place? We're laughing, but it's true, right? We've seen that. So, that takes us to the philosophy of regulating healthcare. It's true, right? Did you know this came from Stephen Hawking? I've heard this quote many times. I had no idea it came from Stephen Hawking. So that's kind of the fun trivia for the day. Is punishment a rational approach to improve healthcare?
No.
No,
Of course not.
of course not. Who has successfully beaten their spouse into submission? Or they became a good spouse. Atta girl, atta girl. Atta girl, I got my own. Okay. That's what happens when you marry a cowgirl. So, how about your dogs? Can you beat your dogs nowadays into submission?
No.
You can't do that. That would be mean. Or your children. None of that is right. It doesn't even make any sense. In fact, who probably knows the most about whether or not punishment works is departments of corrections around the world, right? They know about that. And in fact, they've concluded that it doesn't work. It doesn't deter crime. And you guys aren't criminals. So if it doesn't deter criminals, what's it going to do to you? Just going to annoy you, make you you want to do something else and stop, interfere with your ability to actually do what you love, which is helping people. That's a big deal. That's a real problem. So when a legislator like Jesse Danielson, for example, this is a when she says, oh my God, something that I saw on the news that I heard from one of my constituents that happened at this facility, never mind if I've got all the facts right, but I heard this happens, I want to make sure that it never happens again, and so I want to punish them out of existence by increasing the penalties to $10,000 per violation. Not $2,000 a year, but per violation. That's problematic, certainly for everybody in this room, and even for the larger facilities. That is a stinger. So it doesn't work. It doesn't deter traffic offenses. It doesn't deter criminal behavior. It doesn't deter murderers. It doesn't do anything. So if the Department of Corrections and Department of Justice, and this is all over the world, there was a 25-year study that involved Canadian Department of Justice and our own Department of Justice that concluded this. If it doesn't work anywhere based on their research, we would expect that the science-based organization called the Colorado Department of Public Health would have some data on this that would let us know how to develop an appropriate health policy. And they don't. Of course they don't. Enough of that. But that's what we're stuck with at the moment. And so hopefully CALA will slowly be able to encourage legislators and policymakers to at least get as smart as the prison system. Okay. Interesting in doing the research for this short presentation that the initial charter of the health department was to investigate public health issues and recommend resolutions. That was it. That was it. That's pretty good. That's okay. Good. Something's going on. Go take a look at it and make resolutions. It was a board of doctors, and they had an annual budget of $500,000. That was just before the turn of the last century, by the way. And now they're enforcing standards to, as I said, $10,000 per violation unless they decide that it's egregious. They may exceed this $10,000 cap for an egregious violation that results in death. It might be fair. It might be fair. Or serious injury to a resident after considering the circumstances surrounding the violation. But as we all know and tried to bring to Steve's attention, the variability of survey results is problematic because as business people you want predictable, reliable enforcement of the law so that you can run your business. That's it, predictable, reliable. It's not about, well, it's just a matter of perception. Businesses want predictable and reliable, and it's all over the map. All over the map. We know somebody who died in a place, left out overnight, B-level deficiency. What? Yep, that's right. And other times we have an IJ for a bloody chair that could have been moved. It's very, very difficult to run a business if you can't have reliable and predictable government response. So what do you do about that? We come to these things and we kind of commiserate and moan and whine about it. And yeah, I like the way that everybody's mood just sort of dropped there. Thank you for that. So how do you do that? There's a couple ways to do that. So you get your survey results, and you get them really in two phases, right? First they tell you the bad news, and then perhaps months later, you'll get something in writing that tells you that it was an immediate jeopardy. The irony of that is not lost on anybody in the room. But that's what happens. And then once you have that official notice in writing, you can do something about it. You have 10 days, as Steve correctly identified, to file a request for an IDR. The nature of that request is particular, very particular. You can't just say, oh, I want an IDR, because you will lose and you will waste your time and you have no chance whatsoever if you don't follow their requirements. And then if you don't like that result, you can request an administrative hearing through an appeal, which is worth doing sometimes. So as we go through this IDR discussion, you can decide for yourself whether or not it's worth doing, whether or not you have time to do it properly. It's actually more time consuming to prepare properly the IDR request than to file a request for an appeal. However, the appeal process is more expensive and does require an attorney. No attorney is allowed in the IDR process. So you have two choices. You can go directly to IDR, or you can go directly to administrative hearing, or you can try your hand at the IDR, and if you don't like the result, then go to administrative hearing. Personally, I like that approach. It's worth a shot. Give them a chance to do the right thing. But it can be time consuming to prepare the IDR request. 7 days, business days, 7 business days to file your IDR request, but they will give you a 7-day extension if you ask for more time. Hey, I'm not quite done. I need another 7 days. They'll give you that. And they're pretty good about not making a fuss about that. Yes?
I just did that. I asked for a 7-day extension on a plan of correction. They did not give them a 7-day extension to file the IDR.
So, did you guys hear that? No. Stand up, please, and be forthright to the crowd.
I asked for a 7-day extension.
I help people with plan of corrections. I asked for a 7-day extension. Jason Bull gave it to us. He did not give them a 7-day IDR extension. And they're not backing down. They won't give
So
us.
a 7-day extension on the plan of corrections, but not a 7-day extension.
And they did not tell the owner, they didn't give her a 7-day extension. He did tell her, you can file an IDR, and I'll go ahead and grant you an extension on the POC, but he did not grant the extension on the IDR. So she missed her window to file the IDR.
So as an attorney, I'm telling you that's improper. That's not legal advice. That is judgment. For something that's already happened. That is improper. Somebody over there misunderstood their own regulations as to how it goes. Now, it is true that you have to have your plan of correction in place before you can get your IDR.
I have a question about that though, because now what I'm feeling is happening is that they come on site and you get an IJ.
Oh, sorry. If they come on site and you get an IJ, they're asking you to do a plan of correction right there and then. And then they're calling in to get acceptance of your plan of correction at that time. Does that negate your ability to do or request an IDR?
No, you have to get your plan of correction in place.
Okay.
Well, this is a very exciting topic. I wasn't planning on having Q&A at this point, but let's do it.
I just want it to be understood that it's only on the IJ that they want you to do the plan of correction immediately. And you don't know what you will be fined on the IJ until you get the actual plan of correction. And then you usually have to pay the fine before the IDR, and then you can dispute the fine after your IDR. So it's only immediate plan of correction on an IJ. Within, they can tell you 12 hours. What the last one I knew was 2 hours you have to have it done.
Okay, on the plan of correction piece, that's correct enough. I've pushed it one way or another. With respect to the penalties payment, no. No, that's not true. You do not have to pay the penalty ahead of time. You can protest that. The state, in turn, will then get ridgy and say, well, we won't do your renewal of your license or something. They'll play various kinds of games like that, but it is not required to pay that penalty ahead of time. You just notify them. You have your attorney or us or somebody else notify them, no, this is what we're doing. This needs to be forestalled until after we resolve this disagreement that we're having. Okay. Incidentally, this word, dispute resolution, these words, dispute resolution, that's not actually what's in the regulations. It is an informal review. That's the actual legal term for this. It's an informal review, which they have called an informal dispute resolution in their policy. But it's not really a dispute resolution process, is it? If you've gone through it, you know it's not. It's a review. Do we like what we said? Do we like what your disagreement was? End of story. That's kind of how the whole thing goes. Okay, you guys got all that read? Reminder, all all of this is going to be available to you on slides. You'll be able to get them from us. You'll be able to get them from Peter. Not to worry. The important thing here is that the regulations will say, statute actually says that you can submit a request for an informal review. We've already talked about that a little bit. 7 days, with 10 days with a 7-day extension request. So what is the IDR committee supposed to do? There's some interesting contradictions here as well. It's the role of the committee to make recommendations to the division as to non-compliance or compliance and scope and severity for each deficiency. Now that's what the committee can do. But you can't ask for that unless you have a level D or E deficiency. So if you don't like the A, B, or C, no. You can't ask for them to change the scope of the severity. You can't do that. So there's some oddities that they've got in there. What's more, this comes from a policy. This isn't statute. They came up with their own rules that they then called informal dispute resolution. So, did you guys know there was a policy that describes the IDR approach? Well, lucky for you. Do you have phones?
Yeah.
Okay, everybody hold your phone up. Put it in camera mode. Like you're going to take a picture of me. I'm not kidding. All right, now turn it to that. That's where you can get the policy. Oh, that's not it. Where's my, there you go. Let's try that. That's where you can get the policy. And it's updated periodically, without notice. Isn't that exciting to get all that stuff? Again, you're going to get the slides for this if you want, so you'll be able to play around with your cameras and whatnot more later. So, what can't you do in the IDR request? Now, this is from their policy. You can't challenge the survey process or the professional judgment of the survey team. What? What? That's not much of a resolution of anything, is it?
You're depressing me.
I'm here for you. I'm here for you. So this is the IDR process. You can't challenge the level, extent, or scope and severity of the deficiency or the remedy. What in the world would you want to challenge if not this stuff? Unless it is there's more things you can't challenge there. Unless it's a D or E deficiency. And let's face it, unless it's a D or E deficiency, most of the time you're going to grumble and say, fine, I'll just take care of this A, B, or C stuff. And it's maybe, I don't think they're going to charge you for A, B, or C. So they're going to do whatever, and that's the end of it. And you're only going to fuss about it if it's a D or E. Yes?
What about an IJ?
IJ falls into D.
IDR and IJ or no?
Oh, yeah. IJ falls under D, falls under E, but you can also challenge, with all of them, A, B, C, D, or E. But D or E are where the intermediate conditions come from. And that's where they hit you with the fines and say, oh, we want you to replace your administrator, you need a good consultant, or a management company, et cetera, et cetera. That's where they do all the serious interference with business. Did you guys know this about IDRs? Raise your hand if you're learning something new. Ooh, I like it. Okay, so the bottom line is, it's not about the surveyor conclusion. What's the thing that we all complain about? Surveyor conclusions. What do you mean? We got 4 caregivers standing by the window, and that's an IJ because they could jump out the window, push past these guys. Mm-hmm. There you have it. So no, you can't challenge the surveyor conclusion. What can you challenge? What do you think? Again, except for D or E. All right, the factual stuff. So, you know, that bit of tile sticking up, it's a tripping hazard. Well, can you challenge that? What do you think? Is that, why not? Surveyor judgment, right? Well, what if the surveyor says, you know, it was actually sticking up half an inch, and I could have tripped on it. Could you challenge that? Yeah. Why? Maybe it's not half an inch. Maybe it's a 16th of an inch, something like that. What if they say, you know, that person in that special medical bed with that raises up and lifts, they could have got their head caught back there. You're looking at me funny, but I've seen that. So when they bring out all the surveyors, they start looking for all kinds of stuff. And that was one of the ones. Yeah, that bed, that mechanical bed from State Serve, is it? Is the big company? That mechanical bed that's like all the rest of the mechanical beds is wrong, and it was a hazard. They could have got their head stuck back there. Is there a standard for beds in there? Anywhere in the regulations you seen a standard for beds? No. Something like that. Right. So it's not there. Surveyor judgment. Can you challenge that in an IDR? Well, yes, if it's a DRE. Right? Because that's, again, that's what you're likely to be most upset about, is if it's a DRE deficiency. Then you can challenge the surveyor's judgment. So that's not a DRE thing, and there is no standard for that. So why was it? So when you make your IDR request, you say, there's no standard, or it wasn't big enough for her head. Her head was 12 inches wide, and that was only 8 inches wide. I'm making things up, obviously. Thank you. And the surveyor did know that information. I showed her the head measurements and established that it wasn't something that she could have got her head in. And I don't know how in the world this poor woman managed to hurt herself, but it wasn't that. And the surveyor says, "Well, this is my judgment. You can challenge it, particularly if it's a D or an E. If it's D or an E, you can challenge their judgment. But when you submit the request, it's about the facts. If it's a D or E, you can say, and on top of these facts, which were available to the surveyor at the time or shortly thereafter, on top of these facts, their judgment is way off because of you lay out your expertise there. So the bottom line is, do you disagree with the facts as written? And this is where you put on your thinking caps and go, is that a fact or is that an opinion with respect to the A, B, and C deficiencies? And if it's a D or E, okay, you still want to know facts or opinions, and then you include that in your IDR request. And if you don't lay it out like that, facts, these are the facts that we disagree with, this is the information that was provided to the surveyor at the time, these slides are going to be available to you later. It'll delay your request. So they'll send it back. It's worth reading the policy that I gave you the link to. The policy covers more than assisted living facilities, so we're just going to have to go screen through and set stuff aside that's not relevant to your things. Okay. Now, the IDR process doesn't necessarily seem very fair, does it? No. And we observe that from our friends and colleagues who go through the IDR process. And they walk out a little bit mystified sometimes as to why they lost or were summarily treated badly in the IDR process. Part of it's because they didn't lay it out properly, and part of it's because maybe they just didn't have the facts as they should have, and part of it's because there might be some bias in the process. Again, I encourage you to take a look at the IDR presentation I did for CALA. It's on their website, which goes into a lot more detail on this. It's only like an hour, so it's worth it if you have one of these you want to challenge. So, regardless of what you can ask for, the committee has more choices. They can change, they can sustain it as it's written, they can delete it entirely, they can amend it, they can move it, change the scope and severity of it. They have flexibility, regardless of what you're allowed to ask for. So maybe, after you've gone through the process with them, they'll say, oh, okay, this really was kind of sideways. We should have done something, the surveyor should have done something different. And they can change that. And whether it's what level of deficiency is for you, it matters whether or not you can ask for it. There's another thing there about that. You are entitled to ask for an oral presentation to the IDR committee. But they don't do that anymore, do they? It's all Zoom all the time now. So you can ask for one, but then they'll say, we're not doing in-person meetings anymore. So you don't get to look people in the eye. You don't get to see what the surveyor presents to them in response to your written summary of the facts. You don't get to see that. So it's a little biased. And there's no requirement that the state make it anything less than biased. They just have to provide an informal review. Right? That's all the statute requires. Formal review, not a dispute resolution. And supposing that the division director, Elaine in this case, doesn't like or likes what's been said, they make up their own mind as to whether or not they want to accept the recommendations of the IDR committee.
Wait, can you repeat that? After you go through IDR?
That's right. After you go through IDR, the division director doesn't have to accept the recommendations of the committee. They might, and they usually do, but if for some reason or another they don't like what's said, they can say, okay, we're not going to do that. We're going to set this, and this aside. They have the freedom to do that. I haven't seen that happen yet. On the other hand, the IDR committee might say, all this was nonsense. We're not going to. This is a no deficiency kind of situation. It has no severity whatsoever. And the division director could say, no, we really should zing them for something. Zing them is the legal term for penalize. All right, and that results in a decision letter. Once you have the decision letter, you can appeal to the administrative courts. It's not the end of the story, but the administrative courts operate very much like a regular district trial court. There's discovery, you get to ask them for phone records, you get to ask them for documents supporting their opinion, you get to ask them for their educational background, you get to ask them for all kinds of stuff to support their position on things, and you can challenge them. You get to depose them, you get to have a person that your lawyer talks to and says, okay, now, why did you do this? Now, we know for a fact that you, surveyor, did this and this and this at these other places, and you can make more of a challenge. That's where your lawyers absolutely come in. The standard for the administrative courts is, did the state meet their burden of proof? Now, they have to prove by preponderance of the evidence, which you guys all know from television. It's a good source of education sometimes, as opposed to the news. That the state met their burden of proof. Yeah, that really was a danger. It was a justifiable kind of a situation. That Mrs. O'Leary could have knocked those 4 caregivers out of the way and leapt out that window to hurt herself, and the 4-foot drop, and then run away. Or there wasn't enough evidence. Now, the standard actually calls for substantial evidence. So now we're starting to move a little bit above the surveyor's opinion. But to get there, you have to appeal. So IDR, you start to make your pitch, a little bit of luck, a little bit of posturing, a little bit of how the facts might be, and you might get lucky, and often don't, in my observation. Who's seen somebody win in IDR? 1? 2?
Same one.
Okay, are you the same one, Janet? Okay, all right. Not impossible? Is it worth a shot? Sure. Sure, it's worth a shot. Have a brief conversation with your lawyer and make sure it gets structured properly. Make your request, make your pitch, give it a shot. These are the 3 things that the court will be looking at after we go through the IDR process if we're not successful there. Did they meet their burden of proof? Did they have substantial evidence? Did they follow their statutory authority? So, did they follow their statutory authority? things get a little fuzzy because sometimes they do things beyond their statutory authority. It's not written down. Maybe the statute will say, hey, you guys are supposed to do something in this direction, and the state is supposed to make regulations on it, and then they don't quite cover that area. There's a lot of things to cover in regulation, and so it's not surprising that there's probably mountains of things that they should have put in regulation and just hadn't gotten around to yet. In fact, most of the time they get around to things because something happened, or one of you raises a fuss about something, and they go, oh, we should write something down, so we have some rules about that. So that's how that most often happens. Okay, as we talk about your questions, this is where you can get the slides from us. And do you have any questions? The mood went from fun and jovial to, oh my God, we got serious here for a moment, and now people are thinking and scratching their heads. Yes, Janet?
You know, I know you can't give it a definite number, but do you have a number? Do you have a little bit of a number of what it costs somebody to do an appeal?
It can be quite expensive. The reason quite expensive is going to be anywhere from 50 to maybe even 100,000, depending on what's at stake. That could be quite significant and could be worth it. The new penalties are telling everybody, you got some choices here. You want to get out of the business because we're going to penalize you, or you want to fight about this because of some injustice that's real or perceived from surveyor behavior. It's an issue. It has previously been important to a fair number of people over the last couple of years, and so we've had the opportunity to fight with the department about many things, and in that process, obtain a lot of information from the department that's not otherwise known in the community about their training and background and whatnot. So each one gets a little stronger every time we want to challenge them on their behavior. Any other questions?
I have a question. Maybe it's more meant for Steve, but maybe you have some experience on this too as well. Why does it say on the deficiencies, administrator failed? Why does it not say facility failed? Why is that happening, or why has that happened, or the change?
As to why, as a general regulatory policy, governments like to find people they can hold accountable. And so that has been increasingly the case since 2018, when they made the most drastic revision to the regulations. Is okay, we need an administrator to be held accountable for things. And then all of a sudden, administrators are now supposed to be property managers and maintenance experts and all that kind of. You've just gone way beyond the normal administrator skill set of taking care of people to now being a professional medical healthcare facility business operator, which you may or may not be the owner who's responsible for those things. So it can get kind of tricky on that, and I'm sure that there's plenty of good advice about how to handle that amongst your peers. Does that help?
Oh, coming, Janelle.
I do know of 3 different instances where they lost at the IDR, and they did take it to further mitigation, and all 3 times the state backed down before it went to the final hearing. So I'm thinking that the state doesn't really want to go that far. It's going to cost you money maybe to go that far, but when it gets to the point, the 3 I know, they ended up just dropping the whole thing before it even got there.
Comment on that? Most trials, most of these kind of cases of any kind of litigation doesn't make it all the way to trial, because there's a balancing of decision-making factors for the private party as well as the government about what's at stake and whether or not it's worth fighting. So for you, every single one of these decisions is a business decision. Do I just want to pay the penalty and get on with my life and move on? Or, you know, these people are trying to put me out of business and it's unjust and it's affecting a lot of people. Or, in some cases, you know, them trying to shut me down using penalties and saying that, you know, this is a pattern or this is a pattern is actually potentially going to kill people due to transfer trauma. And you'll notice there was a little soft pedaling about transfer trauma from, I think it was Ombudsman, right? Oh, there's some risks involved. As it turns out, about 30% of the people die if they move against their will, die within the first 3 months if they're efficient from a facility. That's a bloody huge number. Ask the state about it. Yeah, we know it's a risk. We've taken that into consideration. There will be core requests about that in the near future. That's an open records request. Ask them. You guys are responsible for tracking mortality, it says in the statute. How about that mortality? Are you tracking that? Any other questions? Okay, we have a bit of time here. Who wants to hear about FGI? Is it a little unfair to talk to you about that right now, Michelle? Okay, let's bring up Michelle Pinkowski.